The Crimes Act 1900. It's a New South Wales Act and it's over 120 years old. Is it still relevant? If you've been charged with an offence, this is what you need to know. Hi, I'm Richard Bakoss from Camden Solicitors and Conveyancers. This video is about the criminal law, particularly about the Crimes Act. Is it still relevant? And how it might be relevant to you and to me. I'm a lawyer admitted over a decade ago in New South Wales. I have been admitted to act as a lawyer in the New South Wales courts and also in the High Court of Australia. The Crimes Act is relevant if the police have ever rung you up and said you've got to attend court because you've been charged with an offence. Those sorts of offences can include assault occasioning actual bodily harm, assault of a police officer, assault by way of choking, bodily injury due to gunpowder, disease, bodily harm through common assault, through reckless wounding, intention to cause grievous bodily harm, not providing for your wife, your husband, or your servant even, or not providing them food, deprivation of liberty, break and enter, imprisonment, slavery even. Driving offences are also part of this. They can include speeding, driving whilst under the influence of drugs or of alcohol in excess of the legal limit, driving whilst disqualified or unlicensed or even uninsured. All of these matters are things that I've represented people in the courts in relation to. The most common thing that clients that I've represented have said to me after a matter's been held is thanks. Thanks for representing them. Why is that? Well, it's no surprise because at the conclusion of their matter, they've had the experience firsthand of seeing what a lawyer does for a client. A successful outcome in court can include that the client's evidence is put before the court in a clear, concise and in the best, most efficient manner, saving time and also saving the court from getting upset at the person for wasting their time. The lawyer also provides a comprehensive explanation of how the laws dealing with their offence are going to be dealt with by the court, outlining the elements of the offence and what the prosecution is interested in proving to have a successful outcome so that you can deal with those. How do you deal with them? By providing evidence, including mitigating circumstances, also including what the client might have done before, after and during the alleged offence in relation to the offence. The evidence rules are also very important. The evidence rules include things that might relate to evidence put before the court, why that evidence might be dismissed or withdrawn or not considered by the court because of how the evidence was acquired. The lawyer will have outlined to the defence to the courts so that the offence might be withdrawn in the best circumstance. The charges may be dismissed by the court, by the judge or the magistrate. It might be a situation where no further sentence is required by the court. That's a really good outcome. If the offence is carried, then the lawyer can often, actually very often, can result in a much reduced fine or custodial sentence if that's required. It could result in community service or a community service order that is not enforced until such time as perhaps a condition is met. So it's like what used to be called a suspended sentence. They've changed the phraseology, but that's what it is. All right. They're now called community corrections orders or intensive corrections orders. The words used are important. That's where the lawyer can help you. All right. So now let's just get on with it. I'm just going to go into some details and cover one area, assault occasioning actual bodily harm. That's a matter that I've dealt with many clients of, had hearings in relation to those, defended hearings, where the police have tried to enforce an alleged assault occasioning actual bodily harm. All right, it's defined by the courts by any bodily injury that includes any hurt or injury calculated to interfere with the health or comfort of the victim. These things might include scratches, bruising, cuts, abrasions. They'd all come into the definition of assault occasioning actual bodily harm. Therefore, the offence of assault occasioning actual bodily harm occurs when one person assaults another person causing a sustained injury. It's a serious offence, and statistically, the Bureau of Statistics have shown that 16% of offenders dealt with in the local court in relation to this matter, 16% of people charged have received custodial sentences. So that gives you an idea how the courts deal with it as a serious offence. Section 59 of the Crimes Act 1900 states, whosoever assaults any person and thereby occasioning actual bodily harm shall be liable to imprisonment for up to 5 years. All right, that's the maximum penalty for this offence. However, there are two courts that deal with it, the local court and the district court. What does that mean? Well, what it means is if you're in the local court, the maximum penalty you can get is 2 years. But if you're in the district court, the maximum penalty is potentially 5 years. So your lawyer will give you advice in relation to how you can deal with that should, it's called an election. The prosecution might elect to have the matter moved from the local court, which is where they typically start, up to the district court. And if the election is sought, then that will happen because the magistrate has no capacity to restrict it from going there if that's what's been requested by the prosecution. All right. What do the police have to prove if you've been charged with this offence? They've got to prove two things. They are that there's been an assault and that you are the person who caused that assault. So identity is the issue. What are the defences? Well, they include duress, necessity, and self-defence. So they're the things that your lawyer can help you prepare your defence of the matter with. Those things: duress, necessity, and self-defence. All right. We've gone over what the maximum penalties are. So keep a note to yourself that you want to keep it out of the district court, and that's what your lawyer should be trying to do for you. Let me just give a bit of a proviso now. I don't know any of the details of your matter. Everything that I'm saying in this video is general in nature and you can't use it to make determinations in relation to your matter. You should seek independent legal advice. And this is just my opinion, having practiced in the area for over 10 years. All right. As I said, my name's Richard Bakoss. I'm from Camden Solicitors and Conveyancers. The website details are up there. They're on here, if you can see that. Don't know if you can see that. There you go, on the bottom corner. Camden Solicitors Conveyancers, you can give us a ring on the phone, on the internet, on whatever medium you want to use, YouTube or whatever. Anyway, I hope this video has been helpful to you. You can check out our other videos. I'm Richard Bakoss.